Have you ever had someone wave a legal document in your face, convinced they've cornered you with their superior knowledge of the law, only to discover they've just made the biggest mistake of their petty little lives? I'm talking about the kind of person who thinks a cease and desist letter is the nuclear option that will bring any reasonable person to their knees, begging for mercy. Well, let me tell you about the day our neighborhood's self-appointed legal eagle decided to threaten the wrong veteran with the wrong piece of paper, completely unaware that sometimes the apple doesn't fall far from the judicial tree. My name is Robert Bobby Martinez, though most folks around here just call me Bob. I'm 62 years old, a retired Army Master Sergeant who spent 26 years serving this country before settling down in what I thought would be a quiet corner of suburban Tennessee. After 3 tours in Iraq and 2 in Afghanistan, I figured I'd earned the right to tend my vegetable garden, work on classic cars in my garage, and enjoy the simple pleasure of watching the sunrise from my back porch without someone shooting at me. The transition from military life to civilian retirement isn't always smooth, but I'd found my rhythm in the small community of Willowbrook Estates, where the biggest drama used to be Mrs. Henderson's cat getting stuck in the old oak tree every few months. I bought my house on Maple Ridge Drive 7 years ago, a modest 2-story colonial with a decent-sized lot that backed up to a small wooded area. Nothing fancy, but it was mine, and after spending most of my adult life in military housing where you couldn't so much as paint a wall without permission in triplicate, the freedom to make my own decisions about my property felt like the greatest luxury imaginable. I installed a workshop in the garage where I could restore vintage Chevrolets, planted a garden that would make my grandmother proud, and set up a small shed where I kept my tools and lawn equipment. The neighbors were friendly enough, mostly retirees and young families who appreciated having a quiet veteran next door, who kept his property neat and was always willing to lend a hand when someone needed help moving furniture or fixing a leaky faucet. The house came with what I thought were reasonable neighborhood covenants, the usual stuff about keeping grass cut and not parking boats in driveways. I read through them carefully when I bought the place, being a detail-oriented person by nature and training. 26 years in the military teaches you to read the fine print and follow regulations to the letter. The covenants seemed straightforward enough, mostly focused on maintaining property values and ensuring the neighborhood stayed pleasant for families. Nothing in there struck me as unreasonable or overly restrictive. I figured I could live with rules about not having junked cars in the yard or letting the grass grow knee-high. Those seemed like common sense rather than burdensome restrictions. What I didn't fully appreciate at the time was that Willowbrook Estates had a homeowners association that took those covenants very, very seriously. More specifically, it had a president who treated those covenants like sacred scripture and herself like the high priestess appointed to enforce them with religious fervor. Her name was Patricia Williamson, though she insisted everyone call her Mrs. Williamson, and she approached homeowners association leadership with the intensity of a drill sergeant and the flexibility of a concrete wall. Patricia had moved to Willowbrook Estates about 15 years ago after her divorce, and somewhere along the way, she decided that micromanaging her neighbors' property choices was her calling in life. Patricia was one of those people who seemed to have an unlimited capacity for finding problems where none existed and an even more remarkable talent for turning minor issues into major crusades. She had perfectly coiffed silver hair that never seemed to move regardless of weather conditions, wore pantsuits that looked like they'd been pressed with military precision, and carried herself with the bearing of someone who believed she was perpetually surrounded by subordinates who needed constant supervision. In another life, she might have made a decent staff officer, but instead of using her organizational skills for national defense, she'd turned them toward the monumentally important task of ensuring that everyone's mailbox was the approved shade of black and that no one dared to plant flowers that weren't on the pre-approved landscaping list. The first few years after I moved in passed peacefully enough. I kept my property in good condition, followed the rules as I understood them, and minded my own business. Patricia and I had minimal interaction, beyond the occasional polite nod when we encountered each other at the mailbox. I attended a couple of the annual Homeowners Association meetings, sitting quietly in the back while she ran through budgets and discussed thrilling topics like snow removal contracts and playground equipment maintenance. She struck me as overly bureaucratic but generally harmless, the kind of person who probably meant well, but had too much time on her hands and not enough real problems to worry about. That peaceful coexistence came to an abrupt end last spring when I decided to make some improvements to my property. After 7 years of looking at the same basic landscape, I'd saved up enough money to do some projects I'd been planning since I moved in. Nothing dramatic or controversial, just some practical upgrades that would make the place more comfortable and functional for my retirement years. I wanted to expand my workshop space, update some of the outdoor areas where I like to relax, and maybe add a few features that would make entertaining my grown children and grandchildren more enjoyable when they came to visit. The projects I had in mind were all things I'd done research on, checking local building codes and making sure everything would be up to standard. I'd spent enough time dealing with regulations and inspections in the military to know the importance of doing things by the book. I planned to build a small addition to my garage to house my woodworking equipment, construct a modest deck off the back of the house where I could sit and enjoy my morning coffee, and install a storage shed to organize my garden tools and outdoor equipment. All of these seemed like reasonable improvements that any homeowner might want to make, especially someone who'd earned the right to enjoy his retirement in comfort. What I didn't anticipate was that Patricia Williamson had very different ideas about what constituted appropriate home improvements in Willowbrook Estates. The first indication that my peaceful retirement was about to become significantly more complicated arrived on a Tuesday morning in late March, delivered by a very apologetic postal worker who seemed to sense that the certified letter he was handing me contained nothing but trouble. The envelope bore the official letterhead of the Willowbrook Estates Homeowners Association, and even before I opened it, something about the formal presentation and the way Patricia Williamson had signed her name with an elaborate flourish told me this wasn't going to be a friendly neighborhood update about the annual barbecue. Inside was what she had titled a Notice of Architectural Review Committee Violation, though as far as I knew, I hadn't violated anything yet since I hadn't actually started any construction. The letter informed me in language that tried very hard to sound legal and authoritative that my proposed home improvements were in direct violation of Section 4.7 of the Willowbrook Estates Covenants, which required all exterior modifications to be submitted for review and approval by the Architectural Review Committee at least 60 days prior to commencement of work. Furthermore, the letter continued, my failure to submit proper documentation constituted a material breach of my obligations as a homeowner and could result in fines, legal action, and other remedies as deemed appropriate by the association. Thing that struck me most about this letter wasn't the bureaucratic language or even the vaguely threatening tone, but the fact that Patricia seemed to know about my improvement plans before I'd told anyone in the neighborhood about them. I'd been quietly getting quotes from contractors and researching materials, but I hadn't started any work or even applied for building permits yet. Somehow she'd gotten wind of my intentions and decided to head me off at the pass with what amounted to a preemptive strike against projects that existed only in my planning stages. I read through the letter twice, then pulled out my copy of the neighborhood covenants to refresh my memory about this architectural review requirement. Sure enough, buried in the middle of Section 4.7 was language about submitting plans for exterior modifications, though the way it was written struck me as deliberately vague about what constituted a modification significant enough to require committee review. The section mentioned substantial alterations to the exterior appearance of any dwelling, but didn't define what substantial meant, and it included a catch-all phrase about any construction that might impact neighborhood aesthetics or property. Values. My military training had taught me to approach bureaucratic conflicts with patience and proper procedure, so I decided to follow the established process and submit my plans for review. I spent the better part of a week putting together a comprehensive packet that included detailed drawings of my proposed garage addition, deck, and storage shed, along with specifications for materials, contractor information, and even photographs, showing how similar improvements had been implemented on other properties in the neighborhood. I researched comparable home improvements in the area and included documentation showing that my plan changes were well within the normal range of upgrades that homeowners typically made to properties of this age and style. The submission process itself proved to be more complicated than I'd anticipated. According to the covenants, requests for architectural review needed to be submitted to the committee in writing with supporting documentation, but nowhere could I find clear information about who actually served on this committee or how to contact them. The covenants mentioned that the committee would consist of 3 to 5 homeowners appointed by the association president, but no names or contact information were provided. After several phone calls to neighbors who had lived in Willowbrook Estates longer than I had, I discovered that Patricia Williamson was not only the association president, but also appointed herself as the chairwoman of the Architectural Review Committee, and that the other committee members seemed to change frequently and were rarely involved in actual decision-making. Finally submitted my architectural review packet by delivering it directly to Patricia's house, where she accepted it with the air of someone doing me an enormous favor by agreeing to consider my request. She flipped through the documents briefly, made some non-committal noises about the thoroughness of my submission, and informed me that the committee would review my proposal and provide a written response within 30 days, as required by the covenants. She also mentioned, almost as an afterthought, that the review process included a non-refundable administrative fee of $250, which she expected to be paid before the committee would begin their evaluation. The administrative fee struck me as excessive for what amounted to having someone look at a few drawings and photographs, but I paid it anyway, figuring that compliance with the established process was worth the cost if it meant I could move forward with my improvements. Without further conflict, I wrote Patricia a check, got a receipt that looked like it had been printed on her home computer, and settled in to wait for what I hoped would be a reasonable response from the Architectural Review Committee. 2 weeks into the 30-day review period, I encountered Patricia at the neighborhood grocery store, where she made a point of stopping me in the produce section to discuss my submission. She expressed concerns about whether my proposed improvements were in keeping with the character of the neighborhood and suggested that I might want to consider scaling back my plans to something more modest. When I asked for specific feedback about which aspects of my proposal were problematic, she became vague and evasive, talking about overall impact and community standards, without providing any concrete guidance about how I might modify my plans to address her concerns. The more I talked with Patricia, the more it became clear that her objections to my home improvements weren't based on any specific violations of the covenants or legitimate concerns about property values. Instead, she seemed to view any significant home improvement project as a potential threat to her authority and an unwelcome change to a neighborhood that she preferred to keep exactly as it was. She mentioned several times that Willowbrook Estates had always been a stable, traditional community, and that dramatic changes to individual properties could set unwanted precedents for other homeowners who might get similar ideas about upgrading their homes. By the end of our grocery store conversation, I had the distinct impression that Patricia Williamson was going to reject my architectural review submission, regardless of how well documented or reasonable my proposed improvements might be. My instincts about Patricia's intentions proved to be absolutely correct when the 30-day review period expired and I received her committee's official response. The letter that arrived in my mailbox was even more formal and officious than her initial violation notice, printed on heavyweight paper with the Homeowners Association letterhead prominently displayed at the top. Patricia had clearly spent considerable time crafting what she apparently believed was a legally bulletproof rejection of my architectural review submission, complete with numbered paragraphs, citations of specific covenant sections, and language that seemed designed more to intimidate than to inform. The Architectural Review Committee, which I was beginning to suspect consisted entirely of Patricia Williamson consulting with herself, had found my proposed home improvements to be substantially inconsistent with the established architectural character of Willowbrook Estates and potentially detrimental to neighborhood property values and community cohesion. The rejection letter went on to explain that my proposed garage addition would create an unbalanced visual profile for my property, that the deck I wanted to build would establish a concerning precedent for rear yard modifications, and that the storage shed I planned to install would contribute to visual clutter and commercialization of residential space. What made the rejection particularly frustrating was how thoroughly Patricia had mischaracterized my proposed improvements. She described my modest garage addition as a substantial outbuilding that would dominate the property's streetscape, despite the fact that the addition would be barely visible from the street and would actually improve the appearance of my somewhat outdated garage. The deck she portrayed as an elaborate entertainment structure, when it was really just a simple platform that would allow me to step directly from my kitchen door onto a level surface instead of navigating the awkward concrete steps that the builder had installed 40 years ago. The storage shed, which I had planned as a basic 8x10 structure to organize my garden tools and lawn equipment, was characterized in her letter as a commercial-style utility building inappropriate for residential use. She even included photographs that she claimed showed comparable inappropriate structures in other communities, though the buildings in her photos were clearly industrial facilities that bore no resemblance whatsoever to the modest storage shed I had proposed. It was becoming clear that Patricia either fundamentally misunderstood what I was planning to build, or she was deliberately distorting my proposals to justify her predetermined decision to reject them. The rejection letter concluded with an invitation to resubmit my architectural review application with substantially modified proposals that better reflect the community standards and aesthetic values of Willowbrook Estates. However, the specific modifications that Patricia suggested would essentially eliminate everything I wanted to do, leaving me with the option to perhaps build a small flower box or install a decorative mailbox cover. She also mentioned that any resubmission would require another $250 administrative fee and would be subject to the same 30-day review period, during which I would be prohibited from beginning any construction work whatsoever. The more I studied Patricia's rejection letter, the more convinced I became that her objections had nothing to do with legitimate architectural concerns and everything to do with asserting control over what I could do with my own property. I had spent 7 years being a model neighbor, maintaining my property in excellent condition, following all the established rules, and causing no problems for anyone in the community. My proposed improvements were modest, well-planned, and consistent with upgrades that other homeowners had made throughout the neighborhood. The only thing that made my situation different was that Patricia Williamson had apparently decided to make my home improvement project into a test case for the limits of her authority. Rather than immediately resubmitting my architectural review application with the modifications Patricia had suggested, I decided to do some research into how other homeowners in Willowbrook Estates had handled similar improvement projects. I spent several afternoons walking through the neighborhood, taking careful note of the various additions, decks, sheds, and other modifications that had been made to properties over the years. What I discovered was that virtually every house in the community had been modified in some way since the original construction, and many of the improvements were far more substantial than anything I was planning to do. Mrs. Chun, at the end of my street, had built an elaborate gazebo and koi pond that were clearly visible from the road and represented a much more significant change to her property's appearance than my proposed garage addition. The Johnsons on Elm Street had installed a massive deck system that wrapped around two sides of their house and included built-in seating, planters, and decorative lighting. The Williams family had constructed what amounted to a small barn in their backyard to store their recreational vehicles and lawn equipment, a structure that was easily 3 times the size of the storage shed I wanted to build. Most interesting of all was the discovery that Patricia Williamson herself had made substantial modifications to her own property without any apparent architectural review process. She had installed an elaborate landscaping design that included decorative stone walls, a circular driveway that wasn't part of the original property layout, and a screened porch addition that extended significantly beyond the original footprint of her house. When I checked the county records for building permits associated with her property, I found documentation for some of these improvements, but no evidence of the homeowners association architectural review process that she was now insisting was mandatory for my much more modest projects. Armed with this information, I decided to approach Patricia directly to discuss the apparent inconsistency between the architectural review requirements she was enforcing against my project and the improvements that had been approved or overlooked for other properties in the neighborhood. I called her house and arranged to meet with her on a Saturday morning to review my architectural submission and discuss possible modifications that might address her concerns while still allowing me to make the improvements I needed. The meeting took place in Patricia's living room, which was decorated with the kind of formal furniture and carefully arranged accessories that suggested she took great pride in presenting her home as a showcase of proper suburban living. She had prepared for our discussion by laying out copies of my architectural review submission on her coffee table, along with a legal pad filled with handwritten notes and what appeared to be printouts of various covenant sections that she planned to reference during our conversation. Patricia began the meeting by restating her position that my proposed improvements were inconsistent with community standards and would set a dangerous precedent for other homeowners who might want to make similar modifications to their properties. She emphasized that her role as both association president and architectural review committee chairwoman required her to take a long-term view of neighborhood development and to resist changes that might seem reasonable in isolation but could contribute to a gradual erosion of property values and community character. When I pointed out that many other properties in Willowbrook estates had improvements that were comparable to or more substantial than what I was proposing, Patricia's response was that each architectural review application was evaluated on its own merits and that past decisions didn't necessarily establish binding precedents for future reviews. She also suggested that some of the improvements I had observed might have been completed before the current architectural review process was fully established, though she was unable to provide specific information about when that process had been implemented or how it had evolved over time. The conversation became increasingly circular, with Patricia repeatedly returning to vague concerns about community standards and neighborhood character while refusing to provide specific, actionable feedback about how I might modify my proposals to address her objections. It became clear that she had no intention of approving any version of my architectural review submission, and that the meeting was simply an opportunity for her to restate her position and demonstrate her authority over the approval process. As our discussion was winding down, Patricia made a comment that would prove to be a significant mistake in her campaign to control my home improvement project. Patricia leaned back in her perfectly arranged living room chair, her expression taking on the satisfied look of someone who believed she had definitively won an argument, and delivered what she clearly thought was the conversation-ending statement that would put me firmly in my place. Mr. Martinez, she said, her voice carrying the tone of a school principal addressing a particularly stubborn student, I think you need to understand that the Willowbrook Estates Homeowners Association has legal authority over all exterior modifications in this community, and if you proceed with any construction without proper approval, we will have no choice but to pursue all available legal remedies to protect the interests of the community. She paused for dramatic effect, clearly expecting this threat of legal action to bring me to heel, then continued with even greater emphasis. I want to be very clear about this so there's no misunderstanding. Any construction work that begins on your property without Architectural Review Committee approval will be considered a material breach of your covenants, and the association will immediately seek an injunction to halt the work and compel you to restore your property to its original condition. We also reserve the right to pursue monetary damages for any impact your unauthorized improvements might have on neighborhood property values. What Patricia didn't realize was that her escalation to legal threats had just crossed a line that transformed our disagreement from a neighborhood annoyance into something that engaged a very different part of my background and experience. 26 years in the military had taught me to recognize when someone was bluffing about their authority, and her increasingly dramatic language about legal remedies and injunctions suggested that she was operating more on assumption and intimidation than on actual knowledge of what the Homeowners Association could and couldn't legally accomplish. More importantly, Patricia's threat to pursue court action had just activated a resource that she couldn't possibly have anticipated. She was so focused on asserting her authority over what she saw as a recalcitrant homeowner that she had never bothered to learn anything about my family or personal connections. If she had taken the time to research the man she was threatening with legal action, she might have discovered that my eldest son, Michael Martinez, was a sitting judge in the Tennessee Court of Appeals. With 15 years of experience in civil litigation, before his appointment to the bench 3 years ago, Michael had been the first person in our family to attend college, earning his law degree from Vanderbilt University on a combination of academic scholarships and the GI Bill benefits I had transferred to him during my final years of military service. He had built his legal career on exactly the kind of property law and civil litigation issues that Patricia was now threatening to unleash against me, and he had always maintained a particular interest in cases involving homeowners associations and covenant enforcement. Over the years, Michael had handled dozens of disputes between homeowners and their associations, and he had developed strong opinions about the tendency of some HOA leaders to overreach their actual legal authority. During our regular Sunday family dinners, Michael had often shared stories about homeowners association cases that crossed his desk, describing the pattern of intimidation and pseudo-legal threats that some association leaders used to control their neighbors. He had explained how many homeowners were frightened into compliance by official-looking letters and vague references to legal action, even when the association's actual legal standing was questionable, or their interpretation of covenant language was legally unsound. Patricia Williamson was following this playbook almost perfectly, using formal letterhead and legal-sounding language to create the impression of overwhelming authority that she hoped would discourage me from challenging her decisions. What made Patricia's approach particularly problematic from a legal perspective was her apparent assumption that the homeowners association had blanket authority to reject any architectural modification that she personally found objectionable. Michael had explained to me that covenant enforcement was governed by specific legal standards, including requirements that association decisions be reasonable, consistently applied, and based on legitimate community interests rather than personal preferences or arbitrary aesthetic judgments. Association leaders who rejected architectural applications without clear justification or who applied covenant requirements inconsistently could find themselves on the wrong side of discrimination lawsuits or breach of fiduciary duty claims. Patricia's Rejection of my architectural review submission appeared to violate several of these basic legal principles. Her characterization of my modest improvements as substantial alterations was not supported by any objective analysis of their actual impact on property appearance or neighborhood character. Her references to community standards were undermined by the obvious fact that similar or more substantial improvements had been approved or overlooked throughout Willowbrook Estates. Most significantly, her threat to pursue legal action seemed to be based more on frustration with my unwillingness to accept her authority than on any genuine legal violation that would justify court intervention. The conversation in Patricia's living room concluded with her handing me a business card for what she described as the association's attorney, though the card actually belonged to a general practice lawyer in a nearby strip mall whose primary business appeared to be personal injury cases and criminal defense work. She suggested that I might want to consult with my own attorney about the serious legal implications of proceeding with unauthorized construction, clearly expecting that the prospect of expensive legal fees would discourage me from challenging her architectural review decision. As I drove home from that meeting, I found myself thinking about the conversation I would have with Michael when I called him that evening. Over the years, he had always been generous with legal advice for family members, and he had repeatedly told me to contact him immediately if I ever found myself dealing with any kind of legal threat or official action that I didn't fully understand. Patricia's escalation to threats of injunctions and court action clearly fell into that category, and I was curious to get Michael's professional opinion about the homeowners association's actual legal authority and the validity of their threatened enforcement actions. That evening's phone call with Michael proved to be even more enlightening than I had expected. When I described my situation with the Willowbrook Estates Homeowners Association and read him Patricia's rejection letter and legal threats, his response was immediate and decisive. He explained that Patricia's interpretation of the association's enforcement authority was almost certainly overstated, and that her threats of legal action were probably designed more to intimidate than to reflect realistic legal options. Michael asked me to scan and email him all of the documents related to my architectural review submission, including my original covenant documents, Patricia's correspondence, and any other materials that might be relevant to understanding the association's actual legal standing. He also requested that I provide him with information about the other property improvements I had observed in the neighborhood, since inconsistent enforcement of covenant requirements could be a significant factor in any potential legal dispute. After reviewing the documents I sent him, Michael called me back with an analysis that would prove to be the beginning of Patricia Williamson's very serious legal education. He explained that the Willowbrook Estates Homeowners Association appeared to be operating outside the bounds of their actual authority, and that Patricia's threats of court action could potentially expose her to liability for harassment and abuse of process if she followed through on them without legitimate legal grounds. More interesting still was Michael's observation that Patricia seemed to have fundamentally misunderstood the legal requirements for seeking injunctive relief against property improvements. Michael's legal analysis revealed that Patricia's threats were built on a foundation of legal misconceptions that would crumble under any serious scrutiny. He explained that obtaining an injunction to halt construction work required the homeowners association to demonstrate to a court that they had clear legal authority to enforce the restrictions in question, that the property owner's actions constituted an actual violation of properly enacted covenants, and that the association would suffer irreparable harm if the construction were allowed to continue. Patricia's rejection letter failed to establish any of these basic requirements, instead relying on vague aesthetic preferences and unsupported claims about property values that would never survive judicial review. More significantly, Michael pointed out that Patricia's inconsistent enforcement of architectural review requirements throughout Willowbrook Estates had created what legal scholars call waiver by conduct. Essentially, The association had forfeited their right to enforce certain covenant provisions by allowing similar violations to occur without objection over an extended period. The numerous property improvements I had documented during my neighborhood walks, particularly those that had been completed without any apparent architectural review process, established a pattern of selective enforcement that would make it extremely difficult for the association to justify taking legal action against my much more modest proposals. Michael also identified several procedural problems with the architectural review process that Patricia had established. The covenant documents I had provided him showed that the original homeowners association had been designed with specific checks and balances to prevent individual board members from exercising unilateral control over architectural decisions. The Architectural Review Committee was supposed to consist of multiple homeowners with diverse perspectives, and their decisions were supposed to be based on written guidelines that provided clear, objective criteria for evaluating proposed improvements. Patricia's apparent practice of serving as both the association president and the sole decision-maker for architectural reviews violated these structural requirements and raised serious questions about the legitimacy of her rejection decisions. Armed with this legal analysis, I decided to give Patricia one more opportunity to reconsider her position before involving Michael more directly in the dispute. I spent several days drafting a carefully worded letter that addressed the specific legal deficiencies Michael had identified in her rejection of my architectural review submission. The letter requested that the association provide documentation of the architectural review guidelines they were using to evaluate my proposals, copies of similar architectural review decisions from the past 5 years, and clarification about the composition and decision-making procedures of the current Architectural Review Committee. I also requested that Patricia identify the specific covenant provisions that my proposed improvements allegedly violated, and that she explain how those same provisions had been applied to other property improvements throughout Willowbrook Estates. The letter was polite but firm, emphasizing my desire to resolve the dispute through reasonable discussion while making it clear that I was not intimidated by her legal threats and was prepared to pursue all available options to protect my property rights. Patricia's response to my letter arrived within a week and demonstrated that she had fundamentally misunderstood the shift in our dispute from a neighborhood disagreement to a potential legal confrontation. Instead of addressing the substantive questions I had raised about the architectural review process, she doubled down on her threats and introduced new claims about my obligations as a homeowner that were even more legally questionable than her original position. The letter began with Patricia's assertion that my request for documentation about architectural review procedures was inappropriate and disruptive to normal association operations, and that homeowners were not entitled to review internal association decision-making processes beyond the basic information provided in rejection letters. She characterized my questions about inconsistent enforcement as attempts to undermine legitimate association authority through frivolous complaints about other properties, and she suggested that my continued resistance to the Architectural Review Committee's decision demonstrated a pattern of uncooperative behavior that warranted additional association oversight. Most remarkably, Patricia escalated her legal threats by claiming that my letter itself constituted harassment of association officials and that continued correspondence questioning the architectural review process could result in additional fines and sanctions beyond those already associated with my unauthorized construction plans. She informed me that the association had engaged legal counsel to review my case and that any further communication regarding my architectural review submission should be directed through their attorney rather than to association officials directly. Letter concluded with what Patricia clearly intended as the definitive statement that would end our dispute on her terms. She informed me that the Architectural Review Committee's rejection of my submission was final and non-appealable, and that any construction work that began on my property without proper approval would result in immediate legal action to halt the work and recover the association's costs for enforcement activities. She also mentioned that the association was considering implementing additional oversight measures for properties where owners had demonstrated resistance to legitimate community standards, suggesting that my future association interactions would be subject to enhanced scrutiny and restrictions. What Patricia didn't realize was that her escalatory response had just provided Michael with exactly the kind of evidence he needed to demonstrate that the homeowners association was operating outside the bounds of reasonable authority and engaging in what courts would recognize as harassment and intimidation tactics. Her refusal to provide basic documentation about the architectural review process violated fundamental principles of due process, and her threats of retaliation for legitimate questions about association procedures clearly exceeded any authority granted by the covenant documents. More importantly, Patricia's claim that architectural review decisions were final and non-appealable was legally nonsensical and demonstrated a fundamental misunderstanding of property law and association governance. Michael explained that homeowners always retained the right to challenge association decisions through court action if those decisions were arbitrary, discriminatory, or exceeded the association's legitimate authority. Patricia's attempt to insulate her decisions from any form of review or challenge actually strengthened the case that she was abusing her position and operating the association more like a personal fiefdom than a legitimate community organization. Mention of the association's legal counsel was particularly interesting to Michael, since he recognized the attorney's name from Patricia's earlier business card. A quick review of court records showed that this lawyer had virtually no experience with homeowners association law or covenant enforcement, and had never successfully represented an association in an architectural review dispute. His practice focused primarily on personal injury cases and criminal defense work, suggesting that Patricia had chosen legal representation based more on availability and cost than on relevant expertise. Michael's analysis of Patricia's escalatory letter convinced him that the situation had moved beyond the realm of neighborly dispute resolution and into territory where professional legal intervention was both appropriate and necessary. He explained that Patricia's pattern of legal threats, procedural violations, and intimidation tactics created potential liability not just for herself personally, but also for any other association board members who were aware of and approved her actions. The time had come to respond to Patricia's threats with the kind of legal precision and authority that she clearly didn't expect from a quiet retired veteran who just wanted to build a deck and expand his garage. Michael's professional assessment of the situation led to a strategic decision that would fundamentally change the dynamics of my dispute with Patricia Williamson and the Willowbrook Estates Homeowners Association. Rather than continuing to engage with Patricia's increasingly unreasonable demands and escalating threats, Michael recommended that we shift to a more formal legal approach that would force the association to either justify their actions under proper legal scrutiny or abandon their overreaching enforcement efforts entirely. The first step in this new strategy was to document everything that had transpired between myself and the association, creating a comprehensive record that would demonstrate the pattern of arbitrary decision-making, procedural violations, and intimidation tactics that characterize Patricia's approach to architectural review enforcement. Michael requested that I compile all correspondence with the association, including my original architectural review submission, Patricia's rejection letter, our subsequent exchanges, and any verbal communications that I could remember with sufficient detail to include in a formal legal document. While I was assembling this documentation, Michael began his own investigation into the legal standing and operational history of the Willowbrook Estates Homeowners Association. His research revealed several significant problems with the association's current structure and governance that went far beyond the architectural review issues I had been dealing with. The association's corporate registration with the state had lapsed several years ago due to failure to file required annual reports, which technically meant that Patricia was operating an unincorporated organization without proper legal authority to enter into contracts, collect fees, or pursue legal action against homeowners. Even more problematic was Michael's discovery that the association's current board of directors had never been properly elected according to the procedures outlined in the original covenant documents. Patricia had apparently been serving as president for nearly 6 years, well beyond the 2-year term specified in the association bylaws, and the other board positions had been filled through appointment rather than the mayor-when democratic election process that the governing documents required. This meant that the Architectural Review Committee that had rejected my submission was not only improperly constituted, but was operating without any legitimate authority to make binding decisions about homeowner architectural applications. Michael's research also revealed that Patricia had been collecting association dues and architectural review fees without proper financial oversight or transparency. The covenant documents required the association to maintain detailed financial records that were available for inspection by homeowners, and they mandated that any fees or assessments be approved by a vote of the membership rather than imposed unilaterally by association officers. Patricia's practice of charging architectural review fees and depositing them into accounts that she controlled personally violated these requirements and potentially constituted misappropriation of homeowner funds. Armed with this information, Michael drafted what he described as a comprehensive legal reality check, a formal letter that would be sent to Patricia and the association board members, outlining the numerous legal deficiencies in their operations, and providing them with an opportunity to correct their violations before facing more serious legal consequences. The letter was written on Michael's judicial letterhead, though he was careful to note that he was writing in his capacity as my legal counsel rather than as a sitting judge, and it carried the kind of legal authority and precision that Patricia's strip mall attorney could never match. The letter began by identifying Michael as my legal counsel and providing his credentials as a Tennessee Court of Appeals judge with extensive experience in property law and homeowners association disputes. This introduction was designed to make it immediately clear to Patricia that her threats of legal action were now being taken seriously by someone with the knowledge and authority to respond appropriately to her intimidation tactics. Michael then systematically dismantled every aspect of Patricia's architectural review rejection and legal threats, citing specific case law and statutory requirements that demonstrated the association's failure to follow proper procedures. He pointed out that the Architectural Review Committee's rejection of my submission was procedurally invalid because the committee itself had not been properly constituted, according to the association's governing documents, and that the review process Patricia had established violated basic due process requirements that courts had established for homeowners association enforcement actions. The letter also addressed Patricia's claims about the association's authority to seek injunctive relief against unauthorized construction, explaining that courts required homeowners associations to demonstrate actual harm from covenant violations, rather than relying on speculative concerns about property values or neighborhood character. Michael noted that my proposed improvements were modest, well-designed, and consistent with similar modifications throughout Willowbrook Estates, making it extremely unlikely that any court would find them sufficiently harmful to justify the dramatic legal remedies that Patricia had threatened. More significantly, Michael's letter identified several potential legal liabilities that Patricia and the association board had created through their improper operations and enforcement activities. The pattern of selective enforcement that I had documented throughout the neighborhood could expose the association to discrimination, claims from homeowners who had been treated differently based on arbitrary factors rather than consistent application of covenant requirements. Patricia's practice of collecting fees without proper authorization and depositing them into personal accounts raised questions about financial impropriety that could result in both civil liability and potential criminal prosecution. The letter concluded with a formal demand that the association immediately approve my architectural review submission and cease all threats of legal action related to my proposed home improvements. Michael gave Patricia and the board 30 days to respond with either approval of my plans or a detailed legal justification for their continued rejection that addressed the procedural and substantive deficiencies he had identified in their decision-making process. Most importantly, the letter put Patricia on notice that any continued harassment, intimidation, or improper enforcement activities would result in immediate legal action against both the association and its officers personally. Michael explained that homeowners association board members could be held individually liable for actions that exceeded their authority or violated homeowners' rights, and that Patricia's pattern of behavior had already created significant exposure to both monetary damages and injunctive relief that could permanently restrict her ability to serve in association leadership roles. The response to Michael's letter was swift and dramatic. Within 3 days of its delivery, I received a phone call from Patricia that was completely different in tone from any of our previous interactions. Gone was the imperious authority and legal bluffing that had characterized her earlier communications, replaced by a nervous, conciliatory approach that suggested she had finally grasped the seriousness of her legal position. Patricia informed me that the Architectural Review Committee had decided to reconsider my submission in light of additional information that had become available, and that they were prepared to work with me to find mutually acceptable modifications that would allow my home improvement project to move forward. She also mentioned that the association was reviewing its architectural review procedures to ensure they were fully compliant with current legal requirements, and that any fees I had paid would be refunded as part of this process review. Sudden reversal in Patricia's position would have been satisfying enough, but Michael had prepared me for the possibility that her initial response might be tactical rather than genuine, designed to diffuse the immediate legal pressure while preserving her ability to resume enforcement activities once the threat of legal action had passed. He recommended that we not accept Patricia's verbal assurances at face value, but instead insist on formal written approval of my architectural review submission and documented changes to the association's enforcement procedures that would prevent similar overreach in the future. This caution proved to be well-founded when Patricia's follow-up letter arrived several days later, revealing that her apparent capitulation was actually an attempt to maintain control while appearing to comply with Michael's demands. Patricia's follow-up letter revealed the true extent of her desperation and her fundamental inability to grasp that her authority had been permanently undermined by Michael's legal intervention. Rather than providing the straightforward approval of my architectural review submission that any reasonable person would have offered under the circumstances, she attempted to craft a compromise that would allow her to save face while maintaining some vestige of control over the process. The letter was a masterpiece of bureaucratic maneuvering that demonstrated both her unwillingness to admit error and her complete misunderstanding of the legal reality that Michael had so clearly explained to her. The reconsideration that Patricia offered came with a list of conditions and modifications that were nearly as restrictive as her original rejection, though packaged in language that was clearly intended to sound more reasonable and collaborative. She proposed approving a scaled-back version of my garage addition that would be 20% smaller than my original design, supposedly to ensure better integration with existing neighborhood architecture. The deck I had planned would be permitted only if I agreed to use specific materials that she had pre-approved and limited its size to dimensions that were smaller than several existing decks I had observed throughout Willowbrook Estates. Most tellingly, Patricia insisted that any approval would be contingent on my agreement to sign a covenant compliance acknowledgement That would commit me to seeking association approval for any future property modifications, regardless of their size or significance. This document, which she had apparently drafted herself using language borrowed from various legal websites, included provisions that would give the association ongoing oversight authority over maintenance activities, landscaping choices, and even interior modifications that might be visible from the street or neighboring properties. The conditional approval letter also introduced new fees and requirements that had never been mentioned in the original covenant documents or architectural review procedures. Patricia demanded a construction oversight fee of $500 that would allow the association to hire an inspector to monitor my work and ensure compliance with the approved plans. She also required that I post a restoration bond of $3,000 to guarantee that any work that failed to meet association standards could be corrected at association expense, with the bond amount to be forfeited if I failed to complete the project according to the approved specifications. Perhaps most audaciously, Patricia's letter included a deadline provision that required me to accept her conditional approval within 10 days or face automatic rejection of my architectural review submission and renewed enforcement action for any unauthorized construction. She clearly believed that presenting me with a time-sensitive ultimatum would pressure me into accepting her terms without further legal consultation, allowing her to regain control of the situation while avoiding the more serious legal consequences that Michael had outlined in his letter. When I forwarded Patricia's conditional approval letter to Michael, his response was immediate and unequivocal. He explained that her attempt to impose additional conditions and fees on my architectural review submission was legally improper and demonstrated that she still fundamentally misunderstood the association's actual authority. The original covenant documents that governed architectural review contained no provisions for construction oversight fees, restoration bonds, or ongoing compliance monitoring, which meant that Patricia was essentially trying to create new restrictions that exceeded the association's legal authority. More importantly, Michael pointed out that Patricia's conditional approval actually strengthened our legal position by providing additional evidence of arbitrary and excessive enforcement. Her willingness to approve modified versions of my proposals proved that my original submission had never posed the serious threats to neighborhood character and property values that she had claimed in her rejection letter. The fact that she could suddenly find my garage addition acceptable with a 20% size reduction exposed the lack of objective criteria underlying her original decision-making process. Michael also identified the ultimatum deadline as a particularly problematic element of Patricia's response, since it violated basic due process requirements for association decision-making and could be characterized as an attempt to coerce acceptance of improper terms through artificial time pressure. Courts had consistently held that homeowners associations could not use arbitrary deadlines to prevent property owners from seeking legal review of association decisions, and Patricia's 10-day deadline was clearly designed to discourage further legal consultation rather than serve any legitimate administrative purpose. Rather than responding directly to Patricia's conditional approval offer, Michael recommended that we implement the next phase of our legal strategy, which involved filing a formal complaint with the Tennessee Department of Commerce and Insurance, the state agency responsible for regulating homeowners associations, and investigating complaints about improper governance and enforcement activities. The complaint would document the pattern of procedural violations, financial irregularities, and harassment that characterized Patricia's leadership of the Willowbrook Estates Homeowners Association, and it would trigger a state investigation that could result in formal sanctions against the association and its officers. Michael also began preparing a civil lawsuit that would seek both monetary damages and injunctive relief against Patricia and the association board members, based on their violations of my property rights and their improper operation of the homeowners association. The lawsuit would request compensation for the time and expense I had incurred dealing with the association's improper enforcement activities, along with court orders that would permanently prohibit the association from interfering with my architectural review submission and require them to implement proper governance procedures for future enforcement activities. While Michael was preparing these formal legal actions, I decided to conduct my own investigation into Patricia's background and her history with the Willowbrook Estates Homeowners Association. I was curious to learn whether my experience was unique or whether she had a pattern of similar conflicts with other homeowners who had challenged her authority. I began by reaching out to neighbors who had lived in the community longer than I had, asking casual questions about the association's history and previous architectural review decisions. What I discovered was that Patricia's heavy-handed approach to association governance had created significant resentment throughout Willowbrook Estates. Though most homeowners had been reluctant to challenge her directly due to fear of retaliation and concern about legal expenses, several neighbors shared stories about their own frustrating encounters with Patricia's architectural review process, including cases where reasonable home improvement projects had been rejected for arbitrary reasons or subjected to excessive fees and conditions. Mrs. Thompson, who lived 3 houses down from me, described her experience trying to get approval for a simple front porch renovation 2 years earlier. Patricia had required her to submit 3 different sets of plans, pay nearly $800 in architectural review and modification fees, and agree to use specific contractors that Patricia had recommended. The entire process had taken almost 6 months and had cost Mrs. Thompson significantly more than her original budget, leading her to scale back her renovation plans and accept a much less attractive result than she had originally intended. The Rodriguez family had encountered similar problems when they attempted to install a swimming pool in their backyard. Despite the fact that several other properties in Willowbrook Estates had pools that had been installed without apparent association oversight, Patricia had subjected their application to an exhaustive review process that included requirements for landscaping barriers, equipment screening, and maintenance protocols that went far beyond anything specified in the covenant documents. They had eventually abandoned their pool project entirely after Patricia demanded that they post a $10,000 bond to guarantee proper maintenance and threatened to assess the entire association for any property value impacts that might result from their installation. Most concerning was the story I heard from Mr. Peterson, a widower who had been trying for 3 years to get approval for a handicap-accessible ramp at his front entrance. Patricia had repeatedly rejected his applications on the grounds that the ramp would create a non-standard architectural element that could set unwelcome precedents for other property modifications. Despite the obvious necessity of the accommodation and its protection under federal disability law, Patricia had continued to demand modifications and additional documentation that made the project financially unfeasible for Mr. Peterson, who was living on a fixed retirement income. These conversations revealed that my conflict with Patricia was part of a much larger pattern of abuse and overreach that had been affecting Willowbrook Estates homeowners for years. The stories I heard from my neighbors transformed my understanding of Patricia's reign over Willowbrook Estates from what I had initially viewed as a personal conflict into recognition of a systematic pattern of abuse that had been quietly terrorizing homeowners throughout the community for years. Each conversation revealed another layer of Patricia's authoritarian approach to association governance, and it became clear that her treatment of my architectural review submission was relatively mild compared to some of the harassment and financial manipulation that other residents had endured under her leadership. Mr. Chun, whose elaborate gazebo and koi pond I had noted during my earlier neighborhood reconnaissance, shared a particularly disturbing account of how Patricia had attempted to extort money from him long after his landscaping project had been completed. Despite the fact that his improvements had been installed nearly 5 years earlier with no apparent association objection, Patricia had suddenly declared them to be non-compliant with current community standards and had demanded that he pay retroactive architectural review fees totaling $1,500, along with ongoing maintenance oversight assessments of $50 per month. When Mr. Chun had questioned the legitimacy of these retroactive demands, Patricia had threatened to file a lien against his property and had actually retained a collection agency to pursue the unpaid fees. The harassment had continued for months, with collection agents calling his home and workplace demanding payment for what they described as delinquent homeowners association assessments. Mr. Chun had eventually paid the demanded fees simply to stop the harassment. Despite believing that Patricia's claims were legally baseless, the Williams family, whose large storage building I had observed during my property survey, described an even more elaborate scheme that Patricia had orchestrated to extract money from homeowners who had made improvements without going through her architectural review process. She had hired what she described as a community standards consultant to conduct a comprehensive audit of all properties in Willowbrook Estates, identifying modifications that had allegedly been completed without proper association approval. This audit, which had cost the association nearly $3,000 in consultant fees, had produced a list of supposed violations that included virtually every property improvement made in the community over the past decade. Patricia had then sent formal violation notices to dozens of homeowners, demanding retroactive architectural review fees, compliance penalties, and in some cases requiring expensive modifications to bring existing improvements into conformity with standards that she had apparently invented specifically for the enforcement campaign. The Williams family had been told that their storage building, which had been installed by the property's previous owner more than 8 years earlier, needed to be either relocated to a different part of their lot or modified with expensive screening materials to reduce its visual impact. When they had protested that the building had been in place long before Patricia's tenure as association president, she had responded that the passage of time did not eliminate the association's authority to enforce community standards and that all property improvements were subject to ongoing compliance review, regardless of when they had been completed. Most shocking was the revelation that Patricia had been using her position as association president to enrich herself through a variety of questionable financial arrangements that bordered on outright fraud. Several homeowners described being required to use specific contractors for association-mandated improvements, only to discover later that these contractors were paying kickbacks to Patricia in exchange for her referrals. The community standards consultant who had conducted the expensive property audit turned out to be Patricia's nephew, a recent college graduate with no relevant professional experience who had been paid an exorbitant hourly rate for what amounted to walking around the neighborhood with a camera. Mrs. Davidson, who lived near the community entrance, explained how Patricia had convinced the association board to hire her husband's landscaping company to maintain the common areas, despite the fact that his bids were consistently higher than other contractors and his work quality was notoriously poor. The landscaping contract, which Patricia had negotiated without seeking competitive bids, included provisions for emergency maintenance and seasonal enhancement that had allowed her husband to bill the association for thousands of dollars in questionable expenses over the past 3 years. The financial manipulation extended beyond direct contractor relationships to Patricia's handling of association fees and assessments. Several homeowners reported that she had imposed special assessments for community improvement projects that were never clearly defined or completed, with the collected funds disappearing into association accounts that she controlled without oversight. When homeowners had requested financial records to track how their assessment payments were being used, Patricia had claimed that detailed financial information was proprietary association business that individual homeowners had no right to review. Armed with this information about Patricia's broader pattern of abuse and financial impropriety, Michael refined our legal strategy to address not just my individual architectural review dispute, but the systematic violations of homeowner rights and association governance requirements that had characterized Patricia's leadership. He explained that the evidence of financial misconduct and arbitrary enforcement provided the foundation for a much more comprehensive legal action that could result in Patricia's removal from association leadership and the recovery of improperly collected fees for all affected homeowners. Michael also recognized that the scope of Patricia's misconduct made it appropriate to involve additional law enforcement and regulatory agencies beyond the Tennessee Department of Commerce and Insurance. The pattern of kickbacks and financial self-dealing that homeowners had described could constitute criminal fraud, and the systematic harassment of homeowners through false legal threats and improper collection activities violated consumer protection laws that were enforced by the State Attorney General's office. The next phase of our strategy involved documenting the broader pattern of abuse that Patricia had inflicted on Willowbrook Estates homeowners, creating a comprehensive record that would support both civil litigation and criminal referrals. Michael recommended that I encourage my neighbors to file their own complaints with appropriate regulatory agencies, while also gathering written statements that could be used to demonstrate the systematic nature of Patricia's misconduct. This documentation process proved to be easier than I had anticipated, as most of the affected homeowners were eager to participate once they learned that someone was finally taking serious legal action against Patricia's abusive behavior. Mrs. Thompson provided copies of all her correspondence with the association regarding her front porch renovation, including documentation of the excessive fees she had been required to pay and the arbitrary conditions that Patricia had imposed on her approval. The Rodriguez family shared their entire file related to their abandoned swimming pool project, including Patricia's demands for the $10,000 maintenance bond and her threats to assess the entire association for any property value impacts. Mr. Peterson was particularly motivated to participate in the documentation effort, since Patricia's repeated rejection of his handicap accessibility ramp had not only violated association governance requirements, but had also potentially violated federal disability rights laws. Michael explained that Patricia's refusal to accommodate Mr. Peterson's disability-related needs could expose both her and the association to significant federal civil rights liability, and that his case alone might be sufficient to trigger Department of Justice investigation into the association's discriminatory practices. As this broader documentation effort proceeded, Patricia's behavior became increasingly erratic and desperate. Having failed to intimidate me into accepting her conditional approval offer, and apparently sensing that her authority was being challenged on multiple fronts, she began making threats and demands that demonstrated her complete disconnection from legal reality and her growing panic about the consequences of her years of misconduct. The final escalation came when Patricia decided to make good on her threats of legal action by actually filing a lawsuit against me. Patricia's decision to file an actual lawsuit against me represented the culmination of her increasingly desperate attempts to maintain control over a situation that had already spiraled completely beyond her authority. The lawsuit, which she filed in the local county court with the assistance of her inexperienced strip mall attorney, was a document so legally deficient and factually absurd that Michael described it as a masterclass in how not to practice law. When he reviewed the complaint that was served to me on a Thursday morning in late May, the legal filing, titled Willowbrook Estates Homeowners Association, Inc. v. Robert Martinez, sought injunctive relief to prevent me from proceeding with any construction on my property, monetary damages for what Patricia claimed were ongoing violations of community covenants, and attorney's fees for what she characterized as my frivolous resistance to legitimate association authority. The complaint was a rambling 37-page document that read more like an angry personal letter than a professional legal filing, filled with inflammatory language about my deliberate disregard for community standards and pattern of harassment directed against association officials. What made the lawsuit particularly remarkable was how thoroughly it demonstrated Patricia's fundamental misunderstanding of both the facts of our dispute and the basic legal principles governing homeowners association enforcement. The complaint claimed that I had commenced unauthorized construction activities, despite the fact that I had never begun any actual work on my property beyond the planning and permitting stages. Patricia alleged that my architectural review submission had been properly rejected for legitimate community protection reasons, while simultaneously admitting in the same document that similar improvements had been approved throughout Willowbrook estates without explanation of why those approvals had been appropriate while mine was not. Most significantly, the lawsuit revealed that Patricia had apparently fabricated several key facts to support her legal claims. She asserted that the Willowbrook Estates Homeowners Association was a properly incorporated and legally operating community organization with established authority over architectural modifications, despite the fact that Michael's research had already demonstrated that the association's corporate registration had lapsed and that the current board had never been properly elected. The complaint included references to properly enacted architectural review guidelines and consistently applied community standards that simply did not exist in any documented form. Michael's reaction to Patricia's lawsuit was a mixture of professional amusement and genuine concern about the ethical implications of filing such a legally frivolous case. He explained that the complaint violated multiple professional responsibility requirements for attorneys, including the obligation to conduct reasonable factual investigation before filing litigation and the prohibition against making legal claims that are not supported by existing law or good faith arguments for extending existing law. Patricia's attorney had apparently accepted her version of events without conducting any independent verification and had filed a lawsuit that was so factually and legally deficient that it could expose both him and Patricia to sanctions for abuse of the judicial process. Rather than simply defending against Patricia's lawsuit, Michael recommended that we use her decision to involve the courts as an opportunity to seek comprehensive relief that would address not only my individual dispute, but the broader pattern of misconduct that had characterized her leadership of the Willowbrook Estates Homeowners Association. He filed a comprehensive counterclaim and cross-complaint that transformed Patricia's simple injunction request into a complex multi-party lawsuit that would expose her years of abuse to full judicial scrutiny. Michael's responsive filing was a legal document that demonstrated the difference between competent professional advocacy and the amateurish legal work that Patricia had received from her chosen attorney. The counterclaim methodically dismantled every factual and legal claim in Patricia's original complaint, providing documented evidence that contradicted her version of events and demonstrating that her lawsuit was based on a combination of deliberate misrepresentation and fundamental legal ignorance. The cross-complaint expanded the scope of the litigation to include claims against Patricia personally for abuse of authority, breach of fiduciary duty, and intentional interference with property rights. Michael also named the other current board members of the Homeowners Association as defendants, alleging that their failure to provide oversight of Patricia's activities made them complicit in her pattern of misconduct. Most significantly, the cross-complaint sought class action status on behalf of all Willowbrook Estates homeowners who had been subjected to Patricia's improper enforcement activities, creating the potential for a comprehensive legal remedy that would address the systematic violations that had affected the entire community. The filing of Michael's counterclaim and cross-complaint triggered a series of legal developments that quickly overwhelmed Patricia's ability to respond effectively. Her attorney, apparently recognizing that he had gotten involved in a case that was far beyond his expertise and comfort level, filed a motion to withdraw from representation, citing irreconcilable differences with the client regarding litigation strategy. This left Patricia scrambling to find new legal counsel willing to defend the case that was becoming more obviously frivolous with each passing day. More importantly, The expanded litigation attracted the attention of other attorneys who specialized in homeowners association law and had experience with similar cases involving association misconduct. Within 2 weeks of Michael's cross-complaint filing, Patricia received notice that 3 separate law firms were reviewing the case for potential involvement on behalf of affected homeowners, and that the Tennessee Attorney General's office was conducting a preliminary review of the allegations regarding financial impropriety and civil rights violations. The legal pressure intensified when Michael filed a motion for summary judgment that sought immediate dismissal of Patricia's claims against me while simultaneously requesting emergency injunctive relief to prevent further harassment of Willowbrook Estates homeowners. The motion was supported by a comprehensive evidentiary record that included financial documents demonstrating the association's improper operations, sworn statements from multiple homeowners describing Patricia's abusive enforcement activities, and expert testimony from a certified public accountant who had analyzed the association's financial records and identified numerous irregularities that suggested potential embezzlement. The summary judgment motion was scheduled for hearing on a Tuesday morning in mid-June, creating a deadline that forced Patricia to either provide substantive legal responses to Michael's claims or face the possibility of having her entire case dismissed while simultaneously being subjected to court orders that would restrict her future association activities. As the hearing date approached, it became clear that Patricia was unable to mount any meaningful defense to the allegations that Michael had documented so thoroughly. The hearing itself was a devastating public exposure of Patricia's years of misconduct and abuse. The courtroom was packed with Willowbrook Estates homeowners who had come to witness the legal reckoning that many of them had hoped for but never expected to see. Patricia appeared with a hastily retained attorney who had clearly not had adequate time to familiarize himself with the case, and who spent most of the hearing attempting to distance himself from the legal positions that Patricia's previous attorney had taken in the original complaint. Michael's presentation to the court was methodical and comprehensive, walking the judge through the extensive evidence of Patricia's misconduct while simultaneously demonstrating the complete lack of legal foundation for her claims against me. He presented financial records showing that Patricia had improperly collected and used homeowners association funds, documented evidence of her arbitrary and discriminatory enforcement of covenant provisions, and testimony from multiple homeowners describing the pattern of harassment and intimidation that had characterized her leadership. The judge's response to Michael's presentation was immediate and decisive. He granted summary judgment dismissing all of Patricia's claims against me, finding that her lawsuit was entirely without merit and appears to have been filed for the purpose of harassment rather than legitimate legal relief. More significantly, he granted Michael's request for emergency injunctive relief, issuing a temporary restraining order that immediately prohibited Patricia from taking any enforcement actions against Willowbrook Estates homeowners and required her to provide full financial accounting of all association funds that she had collected or controlled during her tenure as president. The court also ordered Patricia to personally pay attorneys' fees and costs associated with defending against her frivolous lawsuit, finding that her legal action had been brought in bad faith and without reasonable basis in law or fact. The monetary judgment against Patricia totaled nearly $15,000, representing compensation for the time and expense that I had incurred dealing with her improper enforcement activities, along with punitive damages designed to deter similar misconduct by other homeowners association officials. Perhaps most satisfying was the judge's concluding observation that Patricia's conduct represented a troubling abuse of authority that demonstrates why homeowners associations must be subject to proper oversight and accountability measures. He ordered that copies of his ruling be provided to the Tennessee Department of Commerce and Insurance and the State Attorney General's office for further investigation of potential criminal violations related to Patricia's financial misconduct. As Patricia left the courtroom that day, her reign of terror over Willowbrook Estates had been definitively ended by the same legal system that she had so confidently threatened to unleash against me. The aftermath of the court hearing was swift and comprehensive, extending far beyond the immediate resolution of my architectural review dispute to encompass a complete transformation of how the Willowbrook Estates Homeowners Association operated and how Patricia Williamson's years of misconduct were finally brought to full accounting. Within hours of the judge's ruling, word had spread throughout the community that Patricia's authority had been permanently dismantled, and homeowners who had suffered under her arbitrary enforcement for years began coming forward with additional evidence of financial irregularities and abusive behavior that they had previously been too intimidated to report. The Tennessee Department of Commerce and Insurance launched a formal investigation into the association's operations within a week of receiving the court's referral, sending investigators to examine financial records and interview affected homeowners about their experiences with Patricia's leadership. The investigation revealed a pattern of financial misconduct that was even more extensive than what had been documented during the litigation, including evidence that Patricia had been systematically overcharging homeowners for architectural review fees, collecting special assessments for projects that were never completed, and directing association contracts to companies that provided her with personal financial benefits. The state investigators discovered that Patricia had established multiple bank accounts using the association's name and tax identification number, but had structured them in ways that allowed her to control the funds without oversight from other board members or homeowners. Over the course of her tenure as president, she had collected nearly $40,000 in various fees, assessments, and penalties from Willowbrook Estates homeowners, but had spent less than half of that amount on legitimate association expenses. The remainder had been used for personal expenses, including payments to her husband's landscaping company that were grossly inflated compared to market rates, and consulting fees paid to family members for work that was either unnecessary or never actually performed. The Tennessee Attorney General's office opened a parallel criminal investigation focusing on potential fraud and embezzlement charges related to Patricia's financial activities. Prosecutors were particularly interested in her practice of threatening homeowners with legal action for violations that were either non-existent or selectively enforced, then offering to resolve the disputes in exchange for payment of substantial fees that were deposited into accounts she controlled personally. This pattern of behavior, combined with her use of the association's official letterhead and legal-sounding language to intimidate homeowners into compliance, constituted what prosecutors characterized as a sophisticated fraud scheme that had operated under the cover of legitimate community governance. While these criminal and administrative investigations proceeded, the civil consequences of Patricia's misconduct continued to unfold in ways that provided both justice and practical relief for the homeowners she had victimized. Michael's motion for class action certification was granted by the court, allowing all affected Willowbrook Estates residents to participate in a comprehensive lawsuit, seeking recovery of improperly collected fees and damages for the harassment and intimidation they had endured. The class action ultimately included 43 homeowners who had been subjected to Patricia's abusive enforcement activities, representing nearly every household in the community that had attempted to make property improvements during her tenure as association president. The financial recovery for affected homeowners was substantial, totaling more than $60,000 in refunded fees, penalties, and damages. Patricia was required to liquidate personal assets to satisfy the judgment, including the sale of expensive landscaping and home improvements that had been funded with money improperly taken from association accounts. The court also ordered her to pay additional punitive damages designed to deter similar misconduct by other homeowners association officials, bringing her total liability to nearly $90,000. More importantly than the financial recovery was the comprehensive reform of the Willowbrook Estates Homeowners Association's governance structure that resulted from the litigation and regulatory intervention. The Tennessee Department of Commerce and Insurance worked with community residents to establish new bylaws and operating procedures that included proper checks and balances on association leadership, transparent financial oversight requirements, and clear procedures for architectural review that protected homeowner rights while maintaining reasonable community standards. The new association board was elected through a democratic process that had been absent during Patricia's tenure, with candidates who were committed to operating the association as a service organization for homeowners, rather than as a vehicle for personal authority and financial enrichment. The architectural review process was completely restructured to include objective criteria for evaluating proposed improvements, reasonable timelines for decision-making, and an appeals procedure that provided homeowners with recourse when they disagreed with committee decisions. Most significantly, the new association leadership implemented a policy of consistent enforcement that eliminated the arbitrary and discriminatory practices that had characterized Patricia's approach to covenant compliance. All existing property improvements throughout Willowbrook Estates were grandfathered as conforming, regardless of whether they had received formal architectural approval, eliminating the threat of retroactive enforcement that Patricia had used to extract money from homeowners who had made improvements years or decades earlier. The criminal investigation ultimately resulted in Patricia pleading guilty to charges of fraud and embezzlement related to her misuse of homeowners association funds. She was sentenced to 18 months of supervised probation, ordered to pay full restitution to affected homeowners, and permanently barred from serving in any leadership capacity for homeowners associations or similar community organizations. The criminal conviction also triggered an investigation by the Internal Revenue Service, which determined that Patricia had failed to report the improperly obtained association funds as income and assessed additional penalties and interest that further increased her financial liability. For my part, the resolution of the dispute allowed me to finally proceed with the home improvements that had sparked the entire conflict more than a year earlier. The new Architectural Review Committee approved my original plans without modification within 2 weeks of my resubmission, acknowledging that the proposed garage addition, deck and storage shed were entirely consistent with community standards and posed no legitimate concerns about neighborhood character or property values. The construction work proceeded smoothly and was completed by early fall, resulting in exactly the kind of modest improvements that any reasonable homeowner should have been able to make without facing harassment and legal threats. The broader impact of Patricia's downfall extended beyond Willowbrook Estates to influence how homeowners associations throughout Tennessee approached enforcement activities and governance oversight. The state legislature enacted new regulations requiring homeowners associations to maintain transparent financial records, follow democratic governance procedures, and provide homeowners with clear appeal processes for challenging association decisions. The case also became a reference point for attorneys and homeowners dealing with similar disputes, demonstrating that abusive association officials could be held accountable through appropriate legal action. Perhaps most satisfying was the knowledge that other homeowners who had been victimized by Patricia's abuse were finally able to enjoy their properties without fear of arbitrary enforcement actions or financial manipulation. Mr. Peterson was able to install his handicap accessibility ramp without interference. Mrs. Thompson recovered the excessive fees she had paid for her front porch renovation, and the Rodriguez family ultimately completed their swimming pool project using the money they recovered from the class action settlement. The experience reinforced several important lessons about dealing with bullies and abusive authority figures, whether in homeowners associations or other contexts. Most importantly, it demonstrated that patient documentation and professional legal response could be far more effective than angry confrontation or emotional appeals. Patricia's power had been built on intimidation and the assumption that homeowners would be too frightened or too financially constrained to challenge her authority effectively. When that assumption proved incorrect, her entire edifice of control collapsed rapidly and completely. The case also highlighted the importance of understanding the legal framework, governing community organizations, and holding leaders accountable when they exceed their legitimate authority. Patricia's misconduct had been able to continue for years because homeowners either didn't understand their rights or were afraid to assert them. Once the legal reality of her position was clearly established and documented, her ability to continue. The abuse was permanently eliminated. Finally, the resolution demonstrated that sometimes the quiet person who just wants to be left alone may have resources and connections that bullies never anticipate, and that underestimating such people can have consequences far beyond what anyone might have imagined when the conflict began. The ripple effects of Patricia Williamson's legal downfall continued to spread throughout the following months, creating changes that extended far beyond the boundaries of Willowbrook estates and influencing how homeowners associations operated across the entire region. The Tennessee Department of Commerce and Insurance used our case as a catalyst for implementing sweeping reforms in homeowners association oversight, establishing new requirements for financial transparency, governance accountability, and homeowner protection that would prevent similar abuses from occurring in other communities. The department's investigation had revealed that Patricia's misconduct was not an isolated incident, but part of a broader pattern of association mismanagement that affected communities throughout the state. Their comprehensive review of homeowners association complaints over the previous 5 years showed that arbitrary enforcement, financial irregularities, and abuse of authority were recurring problems that required systematic regulatory intervention rather than case-by-case resolution. The Willowbrook estate situation provided the political momentum and legal precedent necessary to implement reforms that homeowner advocacy groups had been seeking for years. Under the new regulations, all homeowners associations in Tennessee were required to undergo annual financial audits conducted by independent certified public accountants, with the results made available to all homeowners and filed with the state regulatory agency. Association boards were mandated to follow specific democratic procedures for elections and decision-making, including requirements for advance notice of meetings, transparent voting processes, and documented justification for any enforcement actions taken against individual homeowners. Most significantly, the new regulations established clear legal standards for architectural review processes, requiring associations to adopt written guidelines that provided objective criteria for evaluating proposed improvements and eliminating the kind of arbitrary, aesthetic judgments that Patricia had used to reject my architectural submission. Associations were also required to provide homeowners with formal appeals processes and were prohibited from imposing fees or conditions that were not specifically authorized by their governing documents or state law. The legislative response to our case was equally comprehensive, with the Tennessee General Assembly passing what became known as the Homeowner Protection Act during their next regular session. The legislation created new civil remedies for homeowners who were subjected to abusive association enforcement, including provisions for attorney fee recovery, punitive damages, and injunctive relief that could remove association officials who exceeded their authority. The law also established criminal penalties for association officers who misused community funds or engaged in patterns of harassment and intimidation. The media attention surrounding Patricia's criminal conviction and the subsequent legislative reforms brought national recognition to the issues surrounding homeowners association abuse and the need for stronger oversight of community governance organizations. Legal journals published detailed analyses of our case, highlighting the importance of proper legal representation and systematic documentation in challenging abusive association practices. Homeowner advocacy organizations used our experience as an example of how individual property owners could successfully fight back against association overreach when armed with appropriate legal knowledge and professional support. The impact on Patricia, personally, was severe and long-lasting, extending far beyond the immediate legal and financial consequences of her misconduct. The criminal conviction made it impossible for her to find employment in any capacity that involved financial responsibility or community leadership, effectively ending the career in nonprofit management that she had pursued before becoming involved in homeowners association governance. The financial judgments against her required the sale of her home in Willowbrook Estates, forcing her to relocate to a different part of the state where her reputation for abuse and misconduct was not widely known. More importantly, Patricia's case became a cautionary tale that was widely cited in legal and administrative proceedings involving other homeowners association disputes. Attorneys representing associations in enforcement actions routinely referenced the Willowbrook Estates case when advising their clients about the importance of following proper procedures and avoiding arbitrary or discriminatory enforcement practices. The substantial financial penalties and criminal consequences that Patricia had faced served as a powerful deterrent to other association officials who might have been tempted to abuse their positions for personal gain or ego satisfaction. Transformation of the Willowbrook Estates Homeowners Association itself became a model for how community organizations could operate effectively while respecting homeowner rights and maintaining proper governance standards. The new board implemented regular community meetings, where homeowners could raise concerns and participate in decision-making about association policies and priorities. Financial records were made available online with quarterly updates, allowing residents to monitor how their dues and fees were being used and ensuring that association expenditures served legitimate community purposes. The architectural review process was completely redesigned to focus on objective safety and aesthetic standards rather than subjective preferences of individual committee members. Clear guidelines were established for common improvement projects like decks, sheds, and additions with specific criteria that homeowners could review before submitting applications. The review timeline was reduced from Patricia's arbitrary 30-day process to a maximum of 15 days, with automatic approval for projects that met the published guidelines and fell within specified parameters. Most importantly, the new association leadership established a culture of service rather than control, viewing their role as facilitating homeowner enjoyment of their properties rather than restricting it through bureaucratic obstacles and arbitrary enforcement. This philosophical shift created a much more positive community atmosphere where residents felt comfortable making reasonable improvements to their homes without fear of harassment or excessive regulation. The success of these reforms attracted attention from homeowners associations throughout Tennessee and neighboring states, many of which voluntarily adopted similar governance practices to avoid the kind of legal and regulatory problems that had destroyed Patricia's leadership. Professional association management companies began marketing their services based on their commitment to transparent operations and homeowner-friendly policies, recognizing that the regulatory environment had shifted decisively in favor of property owner protection. For Michael, the case provided valuable experience in an area of law that was becoming increasingly important as homeowners associations proliferated throughout suburban and urban communities. He began accepting additional cases involving association disputes, using the legal precedents and regulatory frameworks that had been established through our litigation to help other homeowners who were dealing with similar problems. His judicial position gave him unique insight into the legal principles governing community organizations, and he became a frequent speaker at legal conferences and homeowner advocacy events about association governance and property rights. The broader legal community recognized the Willowbrook Estates case as a significant victory for individual property rights and proper association governance, leading to its inclusion in law school curricula and continuing education programs for attorneys who specialized in real estate and community association law. The case demonstrated that even powerful-seeming authority figures could be held accountable when their actions exceeded legal boundaries, and that systematic documentation and professional legal representation could level the playing field between individual homeowners and institutional opponents. Years later, when I reflect on the entire experience, I am struck by how a simple desire to build a deck and expand my garage evolved into a comprehensive legal victory that protected not only my own property rights, but those of dozens of other homeowners who had been suffering under Patricia's abusive leadership. The patience and methodical approach that my military training had instilled proved to be exactly the right strategy for dealing with her intimidation tactics and legal threats. The case also reinforced my appreciation for the importance of family relationships and professional expertise in navigating complex legal challenges. Without Michael's knowledge and experience, I would likely have been forced to either abandon my home improvement plans or accept Patricia's unreasonable conditions, perpetuating her abuse of authority and allowing her misconduct to continue affecting other homeowners. Most significantly, the experience demonstrated that sometimes the most effective response to bullying and abuse is not emotional confrontation, but calm, systematic documentation and appropriate legal action that exposes the abuser's conduct to proper scrutiny and accountability. The final chapter of the Willowbrook Estates saga unfolded over the subsequent years as the community transformed from a place dominated by fear and arbitrary authority into a model of how homeowners associations could operate effectively while respecting individual property rights and maintaining genuine community standards. The changes went far beyond simple policy modifications to encompass a fundamental shift in how residents related to one another and how they viewed their collective responsibility for maintaining their neighborhood's character and value. The new association board, elected through the first truly democratic process that Willowbrook Estates had experienced in years, consisted of residents who brought diverse professional backgrounds and a shared commitment to transparent, service-oriented governance, rather than viewing their roles as positions of authority over their neighbors. The new board members understood themselves as stewards of community resources and facilitators of homeowner satisfaction. This philosophical transformation was reflected in every aspect of how the association operated, from the efficiency of architectural review processes to the collaborative approach used for budgeting and long-term planning. The financial recovery from Patricia's misconduct enabled the association to undertake several community improvement projects that had been deferred or canceled during her tenure due to her misappropriation of funds. The community entrance was redesigned with attractive landscaping that welcomed residents and visitors without creating an imposing fortress-like atmosphere. Common areas were upgraded with new playground equipment, walking trails, and recreational facilities that encouraged neighborly interaction and provided families with attractive spaces for outdoor activities. Most importantly, the association established a reserve fund for emergency repairs and capital improvements that was managed through a transparent investment strategy with regular reporting to homeowners. This financial stability eliminated the need for the kinds of special assessments that Patricia had frequently imposed to fund projects that often served her personal interests more than legitimate community needs. Homeowners could plan their household budgets knowing that association fees would remain stable and that any additional expenses would be thoroughly justified and democratically approved. The architectural review process became a source of assistance rather than obstruction for homeowners who wanted to improve their properties. The committee developed comprehensive guidelines that clearly explained what types of projects required formal review and what modifications could be approved automatically based on established criteria. For projects that required individual evaluation, The committee worked collaboratively with homeowners to find solutions that met both community standards and individual needs, rather than simply rejecting proposals that didn't conform to subjective, aesthetic preferences. This collaborative approach proved particularly valuable for homeowners who needed accommodations for disabilities or changing family circumstances. Mr. Peterson's experience with his handicap accessibility ramp became a template for how the association could work with residents to address practical needs while maintaining community appearance standards. The committee developed specific guidelines for accessibility modifications that streamlined the approval process while ensuring that necessary accommodations could be implemented quickly and without bureaucratic obstacles. The transformation of Willowbrook Estates attracted positive attention from real estate professionals and prospective homebuyers who valued the combination of reasonable community standards and homeowner-friendly governance. Property values throughout the community increased steadily as word spread about the association's effective management and cooperative approach to addressing homeowner needs. The neighborhood became known as a desirable place to live, not just because of its physical attributes but because of the positive community culture that had emerged from the ashes of Patricia's authoritarian regime. The success of the Willowbrook Estates transformation became a case study that was referenced by homeowners association, management companies, and community development professionals throughout the region. The Tennessee Department of Commerce and Insurance used our experience as an example of best practices in their training programs for association board members and property managers. The contrast between the dysfunction and abuse that had characterized Patricia's leadership and the effective, transparent governance that followed provided a compelling demonstration of how proper oversight and accountability could transform community organizations. For my own part, the completion of my home improvement projects marked the end of a journey that had begun with simple plans for a garage addition and deck but had evolved into something much more significant. The workshop space I had wanted for my vintage car restoration projects became a reality, providing me with the retirement hobby I had envisioned when I first moved to Willowbrook Estates. The deck allowed me to enjoy my morning coffee while overlooking the small wooded area behind my property, creating the peaceful sanctuary I had sought when I chose to settle in this community. More importantly, the experience had connected me with neighbors I might never have gotten to know under different circumstances. The shared struggle against Patricia's abuse had created bonds of mutual support and cooperation that enriched the entire community. Homeowners who had previously avoided association involvement became active participants in community governance, contributing their professional skills and personal energy to ensuring that the association served its intended purpose of enhancing, rather than restricting, homeowner satisfaction. The legal precedents established through our case continued to provide protection for homeowners throughout Tennessee and other states where similar abuses might otherwise have gone unchallenged. Attorneys representing homeowners and association disputes routinely cited the Willowbrook Estates case when arguing for proper due process, reasonable enforcement standards, and accountability for association officials who exceeded their authority. The substantial financial penalties and criminal consequences that Patricia had faced served as a powerful deterrent to other association leaders who might have been tempted to abuse their positions. Michael's involvement in homeowners association law expanded significantly following our successful resolution of the Patricia Williamson case. His judicial position provided him with unique insights into the legal principles governing community organizations, and he became a respected voice for balanced approaches to association governance that protected both community interests and individual property rights. He frequently spoke at legal conferences and continuing education seminars about the importance of proper oversight and accountability in homeowners association operations. The broader impact of our case extended to legislative and regulatory reforms that strengthened homeowner protection throughout the region. The Tennessee Homeowner Protection Act became a model for similar legislation in other states, providing legal remedies and enforcement mechanisms that helped prevent the kind of systematic abuse that Patricia had perpetrated. The enhanced oversight requirements and financial transparency standards that resulted from our case created a regulatory framework that made it much more difficult for association officials to engage in the kind of misconduct that had characterized Patricia's leadership. Years after the conclusion of the legal proceedings, I occasionally encountered Patricia at community events or business establishments in the broader area where she had relocated following her forced sale of her Willowbrook Estates home. These encounters were invariably awkward, with Patricia typically avoiding eye contact and quickly leaving when she noticed my presence. The criminal conviction and financial judgments had clearly taken a toll on her personal and professional life, serving as a permanent reminder of the consequences that could result from abusing positions of community authority. The experience taught me valuable lessons about the importance of standing up to bullies and abusive authority figures, regardless of their apparent power or institutional backing. Patricia's threats and intimidation tactics had been effective for years because homeowners either didn't understand their rights or were afraid to assert them against someone who appeared to have legal authority and professional support. Once her actual legal position was clearly established and challenged through appropriate channels, her entire edifice of control collapsed rapidly and completely. The case also demonstrated the crucial importance of having access to knowledgeable legal representation when dealing with complex property disputes and institutional opponents. Without Michael's expertise in homeowners association law and his understanding of the regulatory framework governing community organizations, I would likely have been forced to either abandon my improvement plans or accept Patricia's unreasonable conditions. The combination of his professional knowledge and judicial credibility provided the kind of authoritative legal response that Patricia's strip mall attorney couldn't match or effectively counter. Most fundamentally, the Willowbrook Estates experience reinforced my belief that patience, systematic documentation, and professional persistence could overcome even well-entrenched abuse when applied consistently and with appropriate legal support. Patricia's downfall wasn't the result of dramatic confrontation or emotional appeals, but rather the methodical accumulation of evidence and legal precedent that ultimately made her position untenable. The quiet satisfaction of having transformed a community while protecting fundamental property rights provided a sense of accomplishment that far exceeded the simple pleasure of completing my originally planned home improvements. 5 years after Patricia's downfall, I received an unexpected phone call that brought the entire saga full circle in the most satisfying way imaginable. The caller was a reporter from the Tennessee Association Management magazine, asking if I would be willing to participate in a feature article about successful homeowners association reforms. They wanted to photograph my completed home improvements, the garage addition, deck and storage shed that had sparked the entire conflict, as examples of reasonable property modifications that enhanced rather than detracted from community character. The irony was delicious. The very improvements that Patricia had declared substantially inconsistent with neighborhood standards were now being featured as model examples of thoughtful homeowner investment that increased property values while respecting community aesthetics. The magazine article included before and after photos showing how my modest projects had transformed an outdated property into an attractive, functional home that complemented the neighborhood's character perfectly. But the most unexpected twist came when the reporter mentioned that the article was part of a series on association governance reform, and that they had tried to interview Patricia Williamson for her perspective on the changes that had occurred since her departure from Willowbrook Estates leadership. According to the reporter, Patricia had declined to participate, stating through her attorney that she preferred not to discuss her previous community involvement due to ongoing legal and financial obligations. The transformation of Willowbrook Estates stands as proof that sometimes the person you try to intimidate might just have the resources patience, and family connections to turn your world completely upside down. Patricia learned the hard way that threatening legal action against a judge's father rarely ends well for the person making the threats. If you enjoyed this story of justice served cold and want to hear more tales of bullies getting their comeuppance, make sure to subscribe to our channel and hit that notification bell. Trust me, you won't want to miss what happens when arrogance meets its match.